Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you are waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled The ABCs of Land Acquisition. My name is Aaron Liu, and I am a pupil in Chambers with Enquiry and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Enquiry and Associates is a mid-sized law firm that was founded in 1985 by Datuk Enquiry. Our able team today comprises 23 lawyers and a support team of 19 staff. Datuk Ma is today a consultant of the firm following his retirement from the Court of Appeal bench in 2015. And the firm continues its tradition today of working primarily with small medium enterprises, SMEs, family businesses, and individuals. We are a full-service law firm with 4 departments: a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment, industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups also indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO currently being implemented, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. Please visit our website at mawenquai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to a matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Moving on, we have 2 speakers today. Eric is a legal associate in our dispute resolution, individual and family departments. He was graduated from Australian National University with a Bachelor of Laws and admitted to the Malaysian bar in year 2018. Eric's primary areas of practice include general litigation, family, citizenship, adoption, land disputes, and defamation. Our next speaker of the day is Vivian, who is also a legal associate in our dispute resolution and individuals and families departments. She holds a Bachelor of Laws honours from Cardiff University, Wales, United Kingdom, and called to the English bar in July 2016. Subsequently, she was also admitted to the Malaysian bar in year 2017. Vivian's primary areas of practice include general litigation, debt recovery, criminal, land acquisition, probate, and administration of estates, construction, contractual disputes, and tenancy disputes. Before we begin the talk, throughout the talk, if you have any questions, please don't forget to post it up on Slido or in the chat, and we will address them at the end. You can access the Slido page by scanning the QR code on the slide or going to the Slido website and key in the number 201349. The top points for today, there are four top points today, which Eric will cover the first three, which includes the introduction to land acquisition, the land inquiry before the land administrator, and the overview of the proceedings at the High Court. And thereafter, Vivian will share with us the recent and landmark rulings and cases on land acquisition in Malaysia. Now, let us welcome Eric. Eric, over to you.
Thanks, Aaron. Good afternoon, everyone. I hope my screen is visible to everyone. So today, I will be talking about land acquisition in Malaysia. And I'll give a brief overview on what is the law surrounding land acquisition in Malaysia. What happens when your land is suddenly acquired by the government or the state authority? You will have to refer to the Land Acquisition Act. And Section 3 of the Land Acquisition Act allows the state authority to acquire your lands or any other private lands under certain circumstances. So what are these circumstances, and what happens when they do decide to acquire your land, and what is the process? So I'll go through them briefly today. So as mentioned earlier, the Land Acquisition Act allows the government to acquire lands under certain circumstances. So what are these circumstances? Well, firstly, for any public purpose. Secondly, for the benefit of economic development in Malaysia. And thirdly, for the mining, residential, agricultural, or industrial purposes. So if you see the slides, it seems that it's actually quite broad. Basically, as long as the government thinks that your land is needed for whatever purposes that they think will be beneficial to the public or for Malaysia, then they can use the Land Acquisition Act to acquire your land. So for example, if they want to build mosques or highways, MRTs, and of course, currently with the COVID pandemic, maybe they'll need lands for hospitals and such. So these are the public purposes or other economic development purposes that the government can use to acquire your lands. So what happens when the government does decide to acquire the land? So, well, fortunately, you are protected by the Constitution. Article 13 of the Federal Constitution says that no person shall be deprived of property save in accordance with law. And the acquisition must be conducted and adequate compensation must be given to the landowners. And this is reflected in the Land Acquisition Act. So what do we mean by in accordance with the law? So under the Land Acquisition Act, there are actually quite a few steps and procedures that need to be taken and complied with by the state authority or by the acquiring body before the whole land acquisition process is completed and valid. So I set out here some forms that needs to be submitted and issued during the whole land acquisition process. So for example, Form A is what we say is the notification of likely acquisition. So if the government thinks that they will likely need to acquire your land, so they will issue this Form A. The next important form will be Form D for our purposes, because Form D is when the government officially declares that they are going to acquire your land. So that's under Section 8 of the Land Acquisition Act. And after that, you will probably receive a notice that to attend a land inquiry, and that will be a notice in Form E. So Form E tells you that a land inquiry will be conducted by the land administrator, and you as the landowner, or perhaps maybe you are a chargee of the land or a tenant, so you will get all these forms to attend the land inquiry. During the land inquiry, all interested persons will attend, which I mentioned earlier, could be the chargee, could be the tenant, and definitely the landowner as well. So what happens during the land inquiry, this will be before the land administrator, will be he or she will examine the valuation reports they are prepared. So, for example, if you're a landowner, you attend the land inquiry with or without a lawyer, preferably with a lawyer, and then you submit your valuation report to tell the land administrator, okay, so this is what we think our land is worth. And the land administrator during the inquiry can inquire or request even more information from you as a landowner. And of course, anyone can submit the valuation report. And after the whole process is completed, an award will be given by the land administrator. So as mentioned earlier, the valuation reports will be prepared by landowner, and for the state will be by the JPPH, which is the Jabatan Penilaian dan Perkhidmatan Harta. And they are there to make sure that the state is represented and to assist the land administrator to come to what we call an adequate compensation under Article 13 of the Federal Constitution. So, as I mentioned, what happens after the inquiry is a written award will be given by the land administrator, and this is in Form G. It's a continuation of the list of forms earlier that I mentioned. And after that, Form H is what the land administrator will send out to all the interested persons, including the landowner, to tell you what is the written award. And they will annex a copy of Form G as well. And after that, after you receive all this, and then usually what our experience is, likely you won't get what you think your land is valued, because somehow that's how it works. Usually, but sometimes if you're lucky, you actually get what you actually asked for, which happened to one of our clients. We submitted for a certain amount, and the land administrator actually gave that amount. So what happens if you do not get the valuation you sought for? So what you can do is you file what we call the Form N, and the Form N will list your reasons and why you think that value or the compensation given by the land administrator is not adequate, and then you set out the reasons there. And the Form N is to refer your objections to court under Section 38 of the Land Acquisition Act. And you have to file this Form N usually within 6 weeks of the date of the award. So you can object to the amount of compensation. You feel that somehow the land administrator have given the compensation to someone that you think is not deserving or shouldn't be given compensation or portion of the compensation. Or if you think that, let's say the land administrator gave you 100 million for the land and you should be given 80 million, but you only given 50 million and then the rest was given to other people. So the apportionment of the compensation is also another ground that you can rely on when you're filing a Form N. So after you file the Form N, the Form O have to be filed by the land administrator to refer your objection to the High Court within 6 months of receiving that. However, if land administrator fails to file this Form N, then you have to apply for extension of time to extend the deadline to refer the case to the High Court. And if, again, they still fail to do so, then you have to seek directions from court. So Form O will trigger what we call the land reference proceedings. So land reference proceedings will be the proceedings at the High Court, which is where the judge, assisted by 2 assessors, will hear your case and basically rehear the whole case. Will look at your valuation reports again and the rebuttal reports, and they will again determine whether there's any issues with the land administrator's valuation or award, whether it has given to the wrong person, whether it was apportioned wrongly, whether the amount was too little. Sometimes we will also cross-examine the valuers, either the government's valuer or our own valuers, on the information stated in the valuation reports. And the principles that the court and assessors will rely on to determine your compensation is listed in this slide here. And among those are market value, the common ones, market value, severance, which is what happens if your land, let's say the government acquires part of your land, and then that land is severed from the rest of your land. So severance. Interest affection is what happens if it affects the other lands that you have, like the acquisition affects your other lands. Relocation costs, let's say if you were staying there or you have business on the land. So if it's acquired, your relocation costs can be part of the compensation, or any undertaking by the state or the acquiring body to improve the unacquired part. So sometimes the state will say, okay, look, I agree to build maybe a bridge or something on the other land that was not acquired. So, if you can get something in black and white from the state, then you can add that in as a compensation in the final award. So what do we what does the court look at when they determine the market value of the land? So importantly, number one, it is the value of the land on a willing buyer, willing seller basis as at the date of gazette, the Form D. So let's say the Form D was gazetted in the 1st of January this year. The court will look at, so the timing stops there. So, if suddenly your land increases in value after 1st of January, then unfortunately that you cannot rely on that, because that is the cutoff date, is the date of gazette. Another thing is, if to consider market value, if only part of your land is acquired, the court will still consider the value of the land as a whole, but will of course make the appropriate adjustments to determine the value of the part of the land that is acquired, which is quite common. And in the valuation reports, the valuers will usually put in comparable transactions, which means they will try to find lands that are maybe around your land, that was the transactions, how much were they sold, how much was they bought for. They will look for lands that have similar categories. For example, if your land is a building land, they'll look for land like that. If your land is agricultural land, etc. If your land was zoned commercially, then they will look for those. But as much as possible, sometimes they actually cannot find really comparable, as in similar or exactly the same land. So they will have to make adjustments when they value the lands. If your land is a leasehold, then the remaining lease period will be calculated during the compensation assessment process. If there are any buildings on your land when your land is acquired, if your land is if the building is illegally constructed, then the value of that building will be disregarded. Obviously, if you have any development plans already submitted to a local council, then those development plans can be taken into account. So that will probably increase the value of your land, because you will say that, we have already planned to build 30 or 40 story condo or many bungalows on the land, but suddenly you've acquired my land, so I've lost that development potential there. So you can use that to claim for more compensation on that basis. However, importantly, there is a limitation on the award. So you should be very careful on this, and you should have a look and chat with your valuer during the land inquiry process. When you first submit the valuation of your land, you need to know that the High Court, after you file your Form N, the High Court cannot award more than what was claimed at the land inquiry. So if you think that your land is worth, you submitted during the land inquiry, you submitted 100 million, but then after that you discuss with another valuer, or you spoke to lawyers, and then you realize that actually my land is worth 150, 200 million, because certain things weren't taken into account initially. Then unfortunately you cannot claim for 200 million. You can only claim 100 million, or rather, not that you cannot claim, just that the High Court cannot award more than 100 million, because that's what you said the value of your land was worth, or what you claimed for during the land inquiry process was 100 million. And because that is the restriction under paragraph 4 of the first schedule of the Land Acquisition Act. So you have to be mindful of that when you're meeting, even at the land inquiry stage. So cannot stress that enough. That's very important. So what happens even after you go to the High Court? The High Court gave you another amount which you think it is still not enough, still not what you hoped for. Then what you can do is you can try to appeal to the Court of Appeal. However, the venue of appeal is actually quite limited, in the sense that you can appeal on the quantum of compensation. So if you just merely think that, I should have gotten 100 million, but even after I go to the High Court just gave me 80 million or didn't have any increase, then solely because you think that, I should be given more money, then it won't be a good ground or appealable ground. You can only appeal to the Court of Appeal on questions of law and errors of law made by High Court judge. So, for example, maybe there is certain late payment charges that you think should be 8% instead of 5%, because based on the law, your land was acquired before a certain date, so it should be 8% instead of 5%. Then you can go to court to argue on that. Or if you think that actually this under the law, the compensation shouldn't be given to a certain party because they are barred under the law to do so. Okay, then you can argue that. So there's a question of law that you can go to in the Court of Appeal, but for quantum, you cannot do so. Lastly, for this will be another area, which is judicial review. What is a judicial review? In land acquisition terms, it is just to challenge the authority's decision to acquire your land. It's actually quite difficult to do so because usually, as mentioned previously, the state actually has wide powers to acquire land, and then as long as they fulfill the purpose. So you have to apply for leave of court to judicial review the decision, and you must apply within 3 months from Form D or Form E. So right after you are informed that your land is being acquired, then you should, and if you think that you want to challenge the acquisition itself, you think you have maybe you have good grounds to do so, then you should quickly engage a lawyer, get a lawyer's advice to see whether you can file a judicial review of that decision to acquire land. 3 months, you have to remember that. So to succeed on a JR, you have to prove bad faith, improper purpose, illegal, or not according to the law. So, for example, there was actually a case whereby the declared purpose for the acquisition of the land was to build a mosque, and that would fall under the public purpose under Section 3. However, what happened was it was discovered that the acquiring body intended to use the land as more than just for mosque. They're going to have a cemetery there and even other buildings there, and these were not declared in the Gazette. The Court of Appeal in that case, in the UAE case, they quashed the acquisition because the purpose was not what was declared in the Gazette. So this is one ground to challenge acquisition. So I think now I will pass on to the floor to Vivian, and she will talk about the recent and landmark rulings and cases at the courts regarding land acquisition matters. Over to you, Vivian.
Thank you, Eric. Okay, as you all know, the Land Acquisition Act is actually quite an old act with a recent amendment in 2016. The act is 1960, amended recently 2016. So there's a lot of, the law on land acquisition is still developing, and we can only glean the principles from the case laws which were passed in the recent years. And as you can see on your screen right now, a few landmark cases I'm sure you have heard before. We have to start with Semenyih Jayo versus PDD Hulu Langat. That was a federal court decision in 2017. And then after that, recently, I think sometime in January this year, 2 federal court decisions, which was Orchard Circle and followed by Amitobha Guho. And then I'll bring you to a few other high court cases in regards to recent developments in the Land Acquisition Act. So the first case that I would like to speak about is Semenyih Jayo. It's a federal court case. What happened was that 3 questions of law were actually raised, which is number 1, whether there is a right of appeal on question of law in light of Section 40D3 and Section 49 of the Land Acquisition Act. As Eric explained earlier on, there is a bar to appeal in land acquisition matters, especially when it has to do with compensation. So Semenyih Jayo was a federal court case which deals with this question, whether you can appeal despite this bar of appeal under Section 40D. The second question of law raised was whether Section 40D is constitutional in the face of Article 121. Section 40D basically says that, in summary, it says that the judge hearing the land acquisition will be accompanied by 2 assessors, and all the judge has to do is to rubber stamp the assessor's decision in terms of the valuation of the market value, whether there's IA, whether the whole compensation is to be decided by the assessors, and all the judge has to do is just to rubber stamp. So the question of law was whether this was constitutional, whether this was right. And the third question of law was whether the right to adequate compensation under Article 13 of the Federal Constitution is safeguarded where the land administrator refused to take into account the development or profit value of the land. So in Semenyih Jayo, interestingly, I'm sure like all other lands, development has started. There was a development plan, it was approved, and work has actually started. So the question was whether compensation ought to be awarded by taking into account development or profit value of the land. Because if we're just purely looking at the first schedule of the Land Acquisition Act, there is no specific provision for profit value or development value, nothing of that sort. So in the circumstances, based on the facts of this case, whether by not giving compensation for development value, whether that is constitutional, whether that safeguards your right to property under Article 13 of the Federal Constitution. So what the Federal Court held was that Section 40D is unconstitutional because it says the amount of compensation shall be the amount decided by the assessors. The Federal Court say no, that's not the case. Second, if the amount of compensation decided by the two assessors differs, then the judge shall elect to concur with one of the assessor's opinion. The Federal Court say no, that is not the case. And thirdly, the amount of compensation shall be the decision of the assessors. Again, like I said earlier, the Federal Court said no. The Federal Court said the power to award compensation in land reference proceedings is a judicial power that should rightly be exercised by a judge and no other. So what happened is that, yes, the judge has two assessors with him, a private assessor and a government assessor. All they have to do is to give their opinion in writing in terms of what compensation is to be awarded. And then the judge with judicial power is supposed to decide where he can either choose government's assessor assessment or the private valuer's one, or he can at his own discretion decide to award something which differs from what the other two have opined. And the Federal Court in Semenyih Jayo specifically emphasized on the principle of equivalence in land acquisitions to protect the right to adequate compensation. So it says, it is our finding that the principle of equivalence requires that the appellant is compensated for his true loss, and it must include compensation for loss of its business. So in this case, even though the Land Acquisition Act doesn't provide for compensation for any loss of business, any loss of profit, any losses incurred in terms of development, the Federal Court held that yes, it is allowed because the utmost principle in land acquisition matters is that the landowner has to be compensated to put them in a place in the same financial position as if there was no land acquisition. So what this principle of equivalence says places the person in the same financial position as he would have been had there been no question of his land being compulsorily acquired. So the purpose of compensation, the purpose of land acquisition proceedings is to put you back into where you were previously in terms of financially, as if your land has not been taken away. So in Semenyih Jayo, they have expended a lot of time and cost in getting the development plan. They have hired engineers, architects, and etc. in getting, and they in fact have started work on the development in the construction. And hence, had there been no acquisition, they would have earned some profit. They would have earned profit from selling the units, and hence the court said, okay, because we have to protect your right under the Federal Constitution, your right to property, we have to award you for the losses that we have incurred because of the acquisition. I will now move on to the next Federal Court case, which is the Orchard Circle. Orchard Circle is quite an interesting case because what happened was Orchard Circle has 2 plots of land, and while they were in the midst of planning on how to develop the land, they found out that the land was actually acquired. Form D was actually issued in 2001. And then an inquiry was held subsequently in 2002, but Orchard Circle was not present. All right, Orchard Circle was not present. They found out that at the inquiry, Orchard Circle was awarded a nominal sum of 1 ringgit for about 17,000 square meters of land. So what they did was, they filed an application for judicial review. They said to ask for an order that either the land reference proceedings, the land inquiry be quashed to be declared null and void, or quash the award, or to get damages, right? So all they are saying is, look, I wasn't present at the land acquisition. The land acquisition ought to be quashed. It's null and void. And alternatively, give me damages for what I have suffered because the land is mine, right? So what the High Court decided was the High Court said, okay, since you were not present at the land inquiry, there was a breach of natural justice because all interested persons, especially landowners, have to be present, are required to be present at a land inquiry. The land inquiry should not proceed without the presence of all interested persons, right? So the High Court said, okay, you were not present, so the inquiry was quashed. The award was quashed, and the High Court said, okay, I'll send you back for another land inquiry, and you have to be present. So the second inquiry was held in 2011. Orchard Circle was there. This was the second inquiry, yeah? So land administrator ordered that the issue in relation to lapse Form D did not arise. Okay, so bring it back a little bit. What happened is that the Form D was issued in 2001, correct? Form D was issued in 2001. Enquiry was held in 2002. 7 years later, Orchard Circle found out. Orchard Circle filed judicial review to quash. It was quashed. And then in 2012 was the second inquiry. 2001, Form D issued. 2012. That was about easily 11 years, 9 years. A long period of time has passed, okay? And what happened is that Form D basically says that upon 2 years of the issuance of Form D, land administrator has to give its award, right? And Orchard Circle bring the issue and said, Form D was issued in 2001. It's already 2012 now. So Form D has lapsed. The acquisition should be null and void. So the land administrator said, no, Form D did not lapse because an award was given then, and this is merely an extension because a High Court order for a re-inquiry. So that Form D is still valid. Orchard Circle being dissatisfied, they file another judicial review to the High Court and say, look, this second inquiry, this second award ought to be quashed because Form D was not valid. And the High Court declared that the acquisition was null and void and that Orchard Circle was the lawful proprietor. What happened then? The land administrator appealed together with land administrator appealed. The Court of Appeal allowed the land administrator's appeal, and then it went to the federal court because Orchard Circle was not happy. Orchard Circle appealed again to the federal court and federal court decided this way. It says that Form D did not lapse. Form D did not lapse because an award was awarded at that time. So in between, there were legal proceedings going on, there was judicial review going on. Despite all those, it doesn't make Form D null and void, and the award cannot be quashed. So this was what the federal court said. It says, Section 8(4) of the Land Acquisition Act does not apply when the acquisition proceedings is completed and the lands are already vested in the state authority. After the many years, 2011 to 2012, a period of nearly 11-12 years, what happened was that the concessionaire has entered the lands, okay? Highway has already started building, the Silk Highway, and there is no way it would be not fair to take the land away and give it back to Orchard Circle because the highway has been built and there was nothing wrong with Form D being issued at that time. So what happened? The federal court held that there will be floodgates if the Form D is quashed because then any landowner will start filing legal proceedings and try to quash Form D, delay the proceedings, and then try to get the land back. So the federal court said, no, this is a floodgate issue, it's unfair, it will be gravely prejudicial to all parties. So my slight advice here is that if you find out that, okay, your land has been acquired before, and then you're in the midst of developing the land, so what you should do, in my opinion, at first instance is find a lawyer and then file an application to stay the building, the construction, stay everything, fight for your rights, let the court determine whose land is it before you take part in any further land inquiry and etc. Another landmark ruling is Amitobha Guho, another federal court case. Okay, so in this case, there were a few issues. One of the issues was suitability of comparables. In this case, 2 plots of land were acquired. Part of 2 plots of land were acquired. So this landowner actually owns 6 pieces of land. The other 4 lands were contiguous and adjacent lands to these 2 acquired lands, right? So what happened was that during the land reference proceedings, the issue of suitability of comparables arose, meaning the landowner's valuers actually used acquisition comparables, which means if I can go back to what Eric explained earlier, we are supposed to take sale comparables. So when you determine market value, you're supposed to look for sale transactions in the vicinity which have similar characteristics of your land, correct? And there's a slight misconception here that it has to be a sale comparable. So this issue came up in Amitobha Guho, whether it has to be a sale comparable or it can be acquisition comparables, which means lands which were acquired and compensation has been given for those lands in the vicinity. Can those also be used as comparable to determine your market value? A second issue which arose was about late payment charges. So when does the responsibility to pay late payment charges arise? What does it mean when the Act says from the date on which the land administrator took possession of the land? Is it when they enter your land? Is it when award was given? Is it when Form K was issued? So that was also an issue. So what it held was that the amendments to the late payment charges are not retrospective so as to deprive the appellants of their rights to late payment charges. So I think that one Eric has mentioned previously, the Amendment Act from 8% to 5% does not apply to any proceedings before the Amendment Act came into place, which was 1st of December 2017. So if your matter has already been pending before the 1st of December 2017, the rate of late payment charges of 8% still applies. Subsequent dates after 1st December 2017, it will be only 5%. What the Federal Court in Amitobha Guho also decided is that on the two issues which I mentioned just now, the stability of acquisition comparables and also late payment charges, the Federal Court said any comparables can be used as long as it's suitable to determine the market value of the land. The Land Acquisition Act does not say it has to be sale comparable. It says any method of comparison as long as consideration is given to sale comparables in the vicinity and as long as suitable adjustments is made in terms of the difference between your land and the lands in the vicinity. So this is something to take note because I think it's a misconception among the public that, you can only take land which has been sold. There's a sale and purchase agreement. No, that's not the case. Secondly, for late payment charges, when does the date of late payment charges start? It starts when Form K is issued, right? So in this Amitobha Guho case, Silk, the concessionaire, has actually entered and started work even before Form K was issued. And Amitobha Guho tried to argue and say, you entered my land, you ought to pay me late payment charges from that date itself. But the court said, no, it is when Form K is issued. So maybe a slight advice is don't let anyone into your land. They don't have the right to enter your land until they issue Form K to you. A third issue which was raised was to do with costs. So in this case, cost was not awarded by the High Court during the land reference, nor was there any cost awarded by the land administrator during the land inquiry. So Amitobha Guho at Federal Court argued cost ought to be awarded to me because for principle of equivalence to apply in order to be adequately compensated under Article 13, I should be awarded cost. And right enough, Federal Court said, okay, cost at the High Court is at the discretion of the court. But at the land inquiry, the land administrator ought to have awarded costs to you pursuant to Section 14(5) of the Land Acquisition Act 1960. So what costs are you entitled to? It is specifically written that you're entitled to your valuation reports cost, meaning the cost that you have to pay your valuers in full. And you're also entitled to any expenses or disbursements incurred for attending the land inquiry. A point to note is that you're not entitled to costs at the High Court because your claim exceeded the High Court's award by 20%. So the reason why there's this law that restricts your claim is so that no landowners can simply just go and say, my land is actually worth 1 million. I want to start this land reference proceeding. I'm not happy with my award. But actually your land is actually worth 300,000. And then you go and exaggerate claim for 1 million. So the purpose of this is to stop landowners from doing that. So if it's so that your claim is reasonable. So if your claim is it exceeds the High Court's award by 20%, then you're not entitled to any costs. Otherwise, the High Court will generally award costs to you. This is a High Court matter. Chia Eng Huat and PDD Pulau Penang is a judicial review matter. In this case, it was held that any acquisition that privately benefits a third party is ultra vires, Section 3(1)(b) of the Land Acquisition Act. So as Eric explained just now, Section 3(1)(b) of the Land Acquisition Act allows the government to acquire your land for these three purposes: public purpose, economic development, or mining, residential, agricultural, or industrial. So if, number one, the purpose is not as it is stated on the form, or if the purpose is in essence to facilitate a private project you as a landowner can bring judicial review proceedings against the government and say that the acquisition is null and void. This is another High Court matter. This has to do with acquisition of strata properties. So in this Perbadanan Pengurusan Ara Ampang versus PDD Hulu Langat, the High Court held that even after having compensated the parcel owners of strata units for the market value, so for their respective units, so the High Court has paid all the parcel owners, all right? Then the court also held that the management corporation, the MC, is also entitled to compensation because of the acquisition of the common property. So this is an interesting development. Moving on to my last case, this is also a landmark ruling by the Federal Court. It's a case of TNB versus Unggul Tangkas Sdn Bhd. So in High Court, okay, what happened was this. At the land inquiry, TNB was there, Unggul Tangkas, the landowner, was there. TNB argued and said, the compensation should be this, fine. But TNB did not file any valuation reports at the land inquiry. Both TNB and Unggul Tangkas filed Form N to object to the award given by the land administrator. Referred the matter to the High Court. The High Court allowed TNB to intervene, but did not allow TNB to file any valuation reports on the basis that because TNB did not file a valuation report at the land inquiry, TNB is not entitled to file any valuation reports. Secondly, it's also because TNB is not an interested party. TNB is just a concessionaire which is responsible to pay compensation. Okay, so both parties appealed to the Court of Appeal because they were not satisfied with the High Court's additional compensation. And the Court of Appeal agreed with the High Court that TNB should not be allowed to intervene and hence should not be allowed to file valuation reports. TNB again applied to the Federal Court. Let's see what the Federal Court says. So 3 questions were posed. Okay, whether filing an objection via Form N is the only mode available for a paymaster to be a party in land reference proceedings, whether the paymaster has a right to be made a party in a land reference proceeding. Number 3, whether the paymaster, upon giving leave to intervene, can be denied the right to participate and file a valuer's report. So the Federal Court actually dismissed TNB's appeal and say that the Land Acquisition Act is quite clear that you have to file Form N in order to object to the award. So if you think that you're an interested party in the land that's being acquired, you always have to remember to file Form N. Otherwise, you have no right to participate in the land reference proceedings or to object to the award. Secondly, TNB filed an application to intervene, but that was according to the rules of court, which does not apply to the Land Acquisition Act. The Land Acquisition Act is law and rules on its own, and the rules of court does not apply. And number 3, this is important, it says TNB had no legal interest but only pecuniary interest being the paymaster. At the end of the day, TNB is just concerned about its pockets, how deep, it has to dig into its pockets to pay Unggul Tangkas, but they actually do not have an interest in the land. So it says, TNB had no legal interest in the land reference proceedings, being the paymaster at the highest, TNB only had a pecuniary interest. The evidence showed that TNB was not aggrieved by the award, but was merely apprehensive that the outcome might adversely affect its pocket. It was for the land administrator to defend the award, and the land administrator was entitled to lead such evidence, such as valuation reports, as is considered necessary to do so. So TNB's interest is safeguarded by the land administrator. And if TNB thinks that the award is too high, then it's for the land administrator to appeal, but not TNB itself. So High Court was correct to deny TNB's right to tender an evaluation report because every opportunity was available to TNB, but TNB did not do it. So the conclusion is that other than the land administrator, only a person who has properly objected under Section 37 by filing Form N has the right to be a party in land reference proceedings. So lastly, just a piece of advice, what to do if you're a person interested. Upon receiving a notification that your land is being acquired, whether Form D or you've heard some rumors about Form A, which is likely to be acquired, then it's best if you seek a valuer and a lawyer at the same time so that you will know your rights, you know what to do, you know when to file what form, you know when to attend, because at the end of the day, your interest starts from the land inquiry. If there's anything that's missed out, any procedure you didn't comply with, it will be difficult later when you go to court. And especially filing Form N, right? When you file Form N, most of the time, people will just, think, inadequate compensation. The reason why? Because the land administrator did not award me what my valuation report says. So all these things are actually very dangerous because the Form N, whatever reason you have given for your objection, has to be clear so that it doesn't bar your right to appeal later. Okay, and another most important thing is to seek a valuer that is familiar with land acquisition. So don't find a valuer which will inflate your claim, or some valuers will say, yeah, you can claim this. I will put in this amount of claim for you. It won't look good, number one. Number two, you will suffer later in terms of when you go to the court, or when in terms of costs may not be awarded to you because you inflate your claim, things like that. That's my piece of advice. Also, just a side point that I just remembered that's not in the slide is that if your land has been acquired, compensation has been awarded by the land administrator, but you have not received any payment. Because technically speaking, payment has to be made to you within 6 months from the issuance of Form K. So we have this client, what happened is that Form K was not issued, right? Because Form K was not issued, they did not pay. There was an award has been given. So what can you do? Then you can, obviously you have to seek legal solutions, which is to apply to the court for judicial review against the land administrator for failing to pay. That's one. And number two, let's say the matter went to the High Court. You have been awarded further compensation. And then you wait and you still don't get your payment. So what do? You can apply to the court again under Section 33 of the Government Proceedings Act for the issuance of a certificate. So what this certificate says is that, okay, this government body, which is the land administrator, owes you this amount of money pursuant to the High Court order, and you have failed to pay, right? Most of the time, in fact, I would say 99% of the time, once that proceedings is started, it will actually push the land administrator to make payment. Because otherwise, then our client, it's taken them 8 years, 10 years for payment to come through. So if you really want to push them to pay faster, that's probably the only way. But the setback would be, of course, your interest will stop earlier. So it really depends what you want. All right, so that's all for today from my end. I'll pass it back to Aaron.
Thank you, Eric and Vivian, for your sharing. We will now take questions from the participants from Slido. Feel free to ask our speakers any questions that you are unclear or unsure about land acquisition. You can scan the QR code to access the Slido page, or go to slido.com and key in the number 201349. So the questions that are on Slido, the first question is valuation fee claimable at High Court? Vivian, would you like to answer this?
Yes, sure. Thank you, Mr. Wee, for the question. The valuation fee before I go on to whether it's claimable at the High Court, it goes back to whether it's claimable at the land inquiry. And as I explained just now, yes, they have to pay you for the valuation fee at the land administrator at the land inquiry stage. At the High Court, it depends whether you have been awarded additional compensation in the land reference proceedings. So whether an order was given in favor of you will determine whether you will be paid the valuation fee, because that falls under your costs. But specifically valuation fee, no, it falls under the general header, which is cost. And like I said, if you win, if the High Court award more than what the land administrator awarded, then generally speaking, you're entitled to costs, unless your claim is inflated, which is more than 20% than what was awarded, then no cost for you. I hope that answers your question. With regard to the presentation slide, yes, we will be emailing the presentation slide to you.
And the next question on Slido is, if an inquiry or award is quashed and subsequent inquiry is held, wouldn't the land value have increased since the time of the initial gazette? Eric, would you like to answer this one?
Yes, I mean, possibly the land value might have increased. Nowadays, hard to say. But hence, that's why as I mentioned earlier, the deadline is Form D. As long as the gazette itself, the acquisition itself is not invalidated, valuation time period is still from the date of gazette. So even if I started the acquisition was in 2000, and somehow in 10 years later it was sent back for another inquiry, you still have to count it from 2000 and not from 2010. So I think this is quite similar to the situation in the Orchard Circle case that Vivian mentioned earlier.
Yeah, I think to add on to Eric would be that because if it's quashed, okay, what happened is that we have this client, his land was actually acquired in 1995. So now it's already 2021, it's been nearly easily 26 years. So what happened is that the date of valuation is still 1995 and the comparables used still has to be 1995 or at or around the same time. Yes, land value would have increased. How do I put it? But that is not an express factor to take into consideration. What you would have gotten would be interest because you will be awarded interest or late payment charges from 1995 when Form K was issued until now, which is actually, in my client's case, the interest is actually a lot more than the market value which was awarded. So in which there's an inflation in property is already covered by interest.
Thank you, Vivian and Eric. And the next question on the Slido is, any idea if proposed legislation for en bloc redevelopment, strata termination for dilapidated buildings by Lands and Mines Department under the LQA or the strata title amendment? Eric or Vivian?
To be honest, I'm not very familiar with strata titles. Maybe I can pass this to my colleague under the strata team, and we'll get back to you if you can leave your contact details with us. Then we can provide you with a more comprehensive advice.
Yeah, but I guess if the redevelopment involves acquiring or demolishing a strata a condo or something, then some parts of it will fall under the Land Acquisition Act.
Thank you, Vivian and Eric. Are there any further questions from the audience? If there are, you can scan the QR code and come to Slido to place the questions. If not, we shall end today's session.
Thank you, Aaron.
Thank you, Vivian and Eric, for your wonderful insights for today. Before we conclude, I have a few announcements to make. Firstly, please join us again for our upcoming talk, which is held on the 19th of May 2021 on Wednesday. The topic of the talk will be the reinstating a struck-off company, and the speakers for the talk will be our Gan Chung Tie and Ryan Cheong. You can sign up for more MWKA online talks at maoinquiry.com/talks-sign up or scan the QR code. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. And thirdly, follow or like our social media accounts, which are shown on the slides. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30 minutes consultation over the telephone or over video conference. Please fill in the form on our website, and the link is also posted in the chat box. To our guests, thank you for joining us. We hope you have found today's session informative and useful.
Thanks, everyone. Stay safe.
Thank you, everyone. Stay safe and see you at our next talk.
Thank you. Bye-bye.
Thank you. Bye.